Good afternoon to everyone. My name is Tanel Tang. I'm working for the Estonian Ministry of Foreign Affairs and currently posted in the Estonian mission to the Council of Europe. This is a panel or a roundtable discussion called The Rule of Law and the Internet and Practical Steps to Promote Human Rights Online. And the event is organized jointly by the Council of Europe and the Laboratory on the Internet Governance of the Ukrainian Association of International Law. And Mr. Bazhuk is here representing this organization. I would first like to introduce the speakers. We have six speakers. We have, as I already mentioned, Mr. Andriy Bazhuk. Then we have Corina Kalugaru from Moldovan Ministry of Foreign Affairs, Head of Global Affairs and Human Rights Division. Then we have Mariam Yayanidze, Advisor of Human Rights Secretariat at the Office of the Prime Minister of Georgia. Then we have Kaltar Toktun, who is still on his way, I assume, and Mr. Stanislav Putnitsky from the Digital Report and SecDev. This is a Canadian media NGO. I think at the outset I would need to say a few words about the Council of Europe because maybe some of you are not fully aware what this organization is about. It is an intergovernmental organization of 47 member states, and basically countries have come together in the ideals of human rights, democracy, and rule of law. It's not only the European Union of 28, but also some other countries like Russia and Turkey and also the Balkan countries. And while I say this, of course, you understand that not necessarily all the countries have the same views on the human rights and including human rights online. But at the same time, all the countries are bound by the European Convention of Human Rights. And when we talk about human rights online, of course, Articles 8, the right to privacy, and Article 10, the right to freedom of expression are the most important in this context. And then there is a European Court of Human Rights, which is basically a guardian of that convention. The citizens of all 47 member states can take their country to the court if they feel that their rights have been violated, and actually they do take them to the court. The problem is that sometimes the court decisions taken already a long time ago are not being implemented by the member states. Then I should also say a few words about how the Council of Europe works. Basically, it works based on three pillars. It's a standard setting, mostly the conventions, but also soft instruments like recommendations and declarations. Some of you probably know the Budapest Convention on Cybercrime, which is not only Council of Europe member states convention, but convention of other countries as well. There are 42 members, and the Data Protection Convention also relevant in this context, of course. Then the second pillar is the monitoring. Countries basically agree that they monitor each other. There are committees, commissions that check whether the countries follow those conditions set and agreed in the convention. And then there is a very important element, the capacity building. It's very important that the member states, those who may have some challenges and difficulties, get help with actually coming closer and following the human rights standards. I would like to say a few words about soft standards and particularly focus on one of them, which is the Council of Europe Guide to the Human Rights for Internet Users. And then I will give floor to Andri to make a presentation on how their institution has implemented this in Ukraine. Basically, the recommendations do not have the monitoring mechanism, but they advise, they recommend to the member states to follow the principles. And the Guide to the Human Rights of Internet Users, the document that was adopted last year in April and launched and presented first time in the Freedom Online Coalition conference in Tallinn, is one of the recommendations, one of such instruments. But it is something that actually claims to be more, or the countries promoting internet freedom in the Council of Europe see this as something more important than the regular recommendation. And it basically is a document that should tell to the internet users what kind of rights they have based on the European Convention of Human Rights and the case law. And it should tell to the users in a very simple fashion what kind of rights they have, and if the rights are violated, then where they can seek for the remedy. And Council of Europe is currently in the process of implementing this guide. We have project in Ukraine. We have also projects in Georgia and Moldova. And I think that now I would like to give the floor to Andri, who will tell a little bit about his study, how the guide has been implemented in Ukraine.
Okay, please slides, yeah, presentation. Okay. Our research and our project is aimed to implement Council of Europe Guide of Human Rights for Internet Users in Ukraine. And it's only starting of the project. The guide contains some human rights which is available for internet users, such as access and non-discrimination. I
think you can use it just like that.
No. What?
You can use the computer. Use the computer. It's easier.
Okay. Sorry. The guide provides such rights as freedom of expression, information, freedom to assembly and participation, private life and personal data protection, education and capacity building. And for purpose of our research, we created some methodology. We examine, first of all, material norms, if it's available, accessible, adequate, and effective. Then we studied institutional framework, capacity of public bodies to protect, enforce human rights, such as national regulator, our parliamentary ombudsman, our enforcement agencies, and also we use the same methodology. We examined existence, accessible, adequate, and effective such remedies mechanisms. Then we examined our procedural law and other policies related to enforcement and remedies redress mechanisms, such as available in administrative, civil, criminal matters. Also, our ombudsman instruments, such as requests, investigations, and also instruments of mediation, online dispute resolution. We used the same methodology, just evaluating existence, accessibility, adequacy, and effectiveness of such instruments. And after examination of all the issues related to procedural We also examined our practice of our public bodies and our judicial authorities to exercise their competence related to the protection of human rights online. And for such issues, we examined practice exists of national regulator related to consumer protection, our parliamentary control mechanism, such as requests and investigations. Also, we studied practice for combating cyber crimes, and based on such experience, we also tried to implement guidelines in our teaching programs in Institute of International Relations, our bachelor degree in International Information Law, and that's why we use such methodology, proposing students to analyze their agreements with service providers for the compliance with guide for internet users. Then our students sent requests and some claims to providers related to execution of personal data protection rights. And also we, based on such research, analyzed and what is the results. Immaterial norms exist, accessible, but not adequate and non-effective legal framework exists to implement human rights guideline. Also, some gaps exist. For example, lack of provisions related to blocking, filtering, and guarantees for human rights protection. And that's why for our parliament, it's a task to implement several laws related to such issues. That was the case in European Court of Human Rights against Ukraine, that lack of procedural provisions related to blocking of information related to violation of Article 10, freedom of association. Then we analyzed our institutional framework and also existed accessible for offline but not adequate and not effective for online protection. Several bodies have no power and competence to deal with online issues, but only offline. And the same situation is redress and remedies mechanisms. Because of lack of knowledge of judges in dealing with online issues, because of lack of knowledge of our regulator how to promote human rights online, lack of competence to deal with violation of human rights online. And what is the most successful usage of the Guide for Human Rights? It's as teaching material, and results 100%, because it's useful for teaching, it's useful for practical usage and for some practical assignments by students, and it's effective to raise awareness of students and probably not only students. That the conclusion of our research, that for practical implementation of guidelines, not only for raising awareness, for capacity building at national level, should be implemented additional measures at level of material norms, at level of institutional capacities, and as well as procedural law. Such methodology could be used by other members of the Council of Europe to find gaps in regulation, to find some steps necessary to implement guide. And for Ukraine, we plan to continue our project and to amend guide with legal provisions related to our country. Thank you.
Thank you, Andri. Perhaps I should add here as well that this document on which Andri and his institute made the research was agreed by all 47 Council of Europe member states. And this is a bit of a paradox, because if you read this document, you understand that this is highly problematic to some Council of Europe member states. But despite of this, it was agreed, and Estonia, as the facilitator of this process in Strasbourg, basically we did not even meet that much opposition. The debate went rather smoothly. And of course, when we go to the implementation, I think that then we know more about the details, and devil is very often in details, and that's why I think it's very useful, Andri, what you have done. But I think that now I would give the floor to Corina to tell perhaps some of the challenges that Moldova is facing, and after this I will open the floor for some questions and remarks, and then we continue with other panelists. Thanks.
Thank you. In fact, the Republic of Moldova has since 2009 a big boom in development of IT technologies, access to the internet, freedom of expression. And even the developments and the association agreement, visa liberalization of the EU has offered to Moldova another option to look towards freedom of expression and generally the development of internet. And this is why we are looking to the Council of Europe guide a little bit different from the fact that we need to develop and we need to educate the young generation. We need to discuss more about the human rights, but at the same time, we need to discuss about the responsibility. Who should be responsible on the legal framework? Should be the decision makers, or should be everybody from us? And we decided to look at the example of Ukraine, at the example of other Council of Europe member states, but at the same time to develop our own approach towards how we'll apply the Council of Europe guide. At the same time, this approach was decided for the fact that we are talking about a new environment, a new European environment. We're talking about a very big access to the information, but at the same time, we're talking about how we should work, because about when it's internet and where is the social media, we're talking at the same time about propaganda, where nobody can offer a concrete answer or some solutions how to deal it. And if we're talking about restrictions, because we had like a few weeks ago, we started the discussions to amend the legislation with the new provisions from the Budapest Convention. But unfortunately, nor the civil society, nor the journalists didn't look very exactly into the provisions of the convention, nor into how we need to implement. But the most important is to have the very deep discussions and to have an inclusive process where even the young people, even the media, civil society, even the law enforcement structure should offer their views how we need to deal furtherly on the application of the freedom of expression, but at the same time, how we can avoid misunderstandings or to confront the Article 10 of the European Convention on Human Rights. I think I will stop here, and I will...
Okay. Thank you, Corina, very much. I give a time to react if there is a wish to ask questions or comments. If not, if yes, I don't know. If not, then I think we will go on with the presentations. Yes, there is one question. Yes.
Okay, thank you. I'm Muk Sehn. I'm from the National University of Mongolia. I'm interested in the research approach that was used in Ukraine, especially the defilement. It exists accessible, adequacy, and effectiveness. could you explain these elements and how did you use it in evaluating the online freedom in your country?
Thank you, sir, for your question. As you already seen, we evaluated different levels of national system, legal system. At level of material norms, we examined special provisions related to human rights online. Are there any, for example, exist right to access to internet? Then is it right to freedom of expression available for users, internet users? Are there any restrictions on such rights? And we found gaps. For example, such rights as right to be forgotten, not available by now in Ukraine, and some rights related to profiling, which is inconsistent with personal data protection guarantees, also not available in legislation. Then we examined procedural norms and found some gaps. For example, Civil Procedural Code allows judges to restrict, to block publications online by using only general provisions of Civil Procedural Code, allowing judges to use any remedies redress on own disposal, but it doesn't correspond to strict requirements of Article 10, Part 2 of this article of European Convention, based that all restrictions should be prescribed by law. And it's a problem, and it's several cases against Ukraine already found Ukraine violated this convention based on lack of provisions in Ukrainian legal framework. And also we found inadequate competence of some public bodies. For example, national regulator under the law of National Telecommunications Commission, a lack of competence to promote consumer rights, but it has competence to protect human rights, but no competence to promote and to assist consumers. And by evaluating existence, availability, accessibility, and usability, effectiveness of different practices, we found gaps in regulations, and that's why such approach could be used for further implementation of such guide. We know road in which we should go to fully implement guide. Thank you.
Okay, I think that we go now on with the panelists. I will give floor to Mariam to talk a little bit about the challenges in Georgia.
Okay. Dear colleagues, first of all, I would like to thank you, organizers, that I have opportunity to share Georgians' experience in human rights protection online. With this widespread use of internet globally, protection of privacy and personal data is social and other types of networks becomes really challenging issue in most of the countries. In Georgia, we have passed a long path, and now I can proudly say that my country accomplished impressive success regarding the creation of the effective institutional framework to guarantee highest international standards, according to which the recently established Personal Data Protection Inspector operates. Before turning to particular issues, I would like to provide brief information about the international instruments Georgia adheres to. In 2006, Georgia signed and ratified Council of Europe's Data Protection Convention, known as Convention 108. The additional protocol on supervisory authorities and transport data flows was ratified in 2013. At the current stage, both of these instruments are incorporated into the national legislation. Regarding the national legislation, the data protection law was adopted in 2012. The first data protection inspector of Georgia was appointed in July 2013. The functions of the inspector are carried out through the office, and the main purpose is to supervise and monitor that the process of data processing is fully and effectively implemented in line with the current law. It is prohibited to influence or interfere with the activities of DPA, and the inspector enjoys full independence and is not subordinated to any official or other body. Basic functions of the Georgian DPA include dealing with the complaints of citizens, conducting inspections on the basis of the complaint or with DPA's own initiative, consulting public and private bodies as well as individuals, raising awareness and educating public and private sector organizations, and participating in the legislative process. Last year, Georgian DPA became the member of the Central and Eastern European Data Protection Authorities. DPA involved in the implementation of the association agreement with EU and with the liberation process. Now I want to briefly talk about current status on cybercrime. In that regard, the most important cybercrime challenges for Georgia are computer-related frauds, illegal access to computer system, and online infringement of copyright and related rights. Fully comprehending importance of international cooperation in successfully combating cybercrime, Georgia has signed the Council of Europe Convention on Cybercrimes that entered into force in 2012. In this year, Georgian Parliament adopted the law on information security that established basic information security standards for public and private sectors. In December 2012, Special Cybercrime Unit was established within the Central Criminal Police Department of the Ministry of Internal Affairs of Georgia. This unit constitutes the main body responsible for cybercrime investigations and also attains the functions of 24/7 international contact point as requested by 2001 Budapest Convention. Computer and network surveillance can be carried out by virtue of court decision or, in case of urgent situation, by virtue of prosecutorial order in conformity with prerequisites given by Criminal Procedure Code of Georgia. For legalizing computer and network surveillance, prosecutor should provide information that requested covert investigation is prescribed by law, necessary in a democratic society to pursue a legitimate aim and proportionate to the legitimate aim pursued. I would like to give brief information about practical steps to ensure e-governance by Georgia. Data Exchange Agency started in its operation in 2010. The agency has 4 core functions. It is development and coordination of e-governance, development of legal and regulatory framework, ensure information and cybersecurity, and establishment of the integrated data exchange system to ensure access to information resources. As there are dozens of successful projects implemented by the DEA from 2010, I would present only few. For instance, computerization of schools and netbooks for all first grades, e-auction of state property, e-notary, centralized criminal case management, real-time cross-settlement system on national bank. E-Georgia Strategy and Action Plan 2014-2018 illustrates the path leading to a modern Georgia and provides a comprehensive framework for societal change enabled by information and communication technology. The role of government is to stimulate innovation in public, private, and civic sectors to ensure economic and sustainable growth. As I have talked about achievements of our country reached for last few years, now let me tell you shortly about priorities we have and challenges we are facing. Development of national legislative framework and approximation with European standards, creation of efficient mechanism for dealing with citizens' complaints and conducting inspections, regulating transborder data flows, supporting implementation of the law through developing sector-specific and thematic guidelines, all these are priorities. Of course, there is the need to change the mindset, attitudes, and values of the general public as well as data controllers. We realize that this is just the beginning and a lot has to be done not only from our side but also from general public and all stakeholders involved to develop sound privacy-friendly system in country. But what I can say for sure is that we had a good starting point, and in terms of 2 years' work, we have already achieved important results that we are positively assessed by our international partners. Thank you for your attention, and I'll try to answer questions you might have.
Yes, I think there will be questions for my part. I think I will use the opportunity later to ask
Okay.
about some of the challenges you already mentioned briefly. I will give now floor to Stanislav Putnitsky, who will give a Canadian perspective to the problem and also discuss it from the media point of view. Please.
Thank you, Chair. I'll begin by just briefly explaining what is it that we do exactly, because I think it'll provide context from where I come into this panel, because I'm not a jurist, I'm not a lawyer, so I'm come from a media and communication background personally, but also in terms of the organization that I represent. So we're based in Canada, but what we do is SECDA Foundation runs a website, digital.report, which is a Russian language website targeting kind of countries of the post-Soviet space and trying to bring all these stakeholders, policymakers, NGOs, societies into a dialogue, into sharing of best practices, into the discussion of the common challenges. So this is all to say that this is technically Canada located approach, but also very much immersed in the local realities that we cover on a daily basis on this website. There is also an English part to it, not a huge one at the moment, but still everyone's invited to go see it. So what I would like to do basically is theorize or hypothesize and invite all you to do it with me on the relationship between digital rights and because again, from what we see in our daily work covering ICT and digital developments in post-Soviet space, they're very much connected. I will begin with a quote, just to stress this point. It comes from a book, Who Controls the Internet, one of the kind of first major explorations on the role of the state, media, and the internet. So just about every debate about internet governance is at bottom a debate about speech governance. And again, I can attest to that. This is precisely what we see in the region. So just to put media into this whole equation and get the point across that digital rights or regulations or laws, they don't exist in a vacuum. And in this vacuum, there is not in this vacuum, in the absence of this vacuum, there is a very dynamic relationship between the regimes or the government, the media, public opinion, and the digital rights that are being produced as a result of this dynamic. Everyone, to an extent, influences everyone. But as you can see, the more dominance the regime has over the media environment, the more easily it is to manipulate the public opinion on these issues, and therefore to arrive at the digital rights or digital regulations that are more fitted or suited for, let's say, this or that regime. Again, this comes from the specific situation that we see on the ground, especially in countries like, as of today, Azerbaijan, Uzbekistan, Belarus to a degree. So what follows from this, is that I would propose there is not a correlation, I would not go as far as that, but it is certainly a relationship between the media freedoms or the media environment and the digital rights environment. And these are two tables. One is the Reporters Without Borders report on press freedom from 2014, and from that same year, Freedom of House Net Freedom report. So the left table is the ranking of countries from 1 to whatever 200, 1 being the best, and the second is the ranking of them out of 100 points, 1 being the best, 100 being the worst. And as you can see, again, it's not a perfect correlation, but I'm not insisting that it is, but there is definitely a very clear trend between the general media freedoms and media environment in a country and the net freedom or kind of the digital freedoms and the digital rights in that country. What this translates to more specifically is the following. And I'm taking Russia as the case, but I would argue again that this applies to any environment. So this is a survey done recently by one of Russia's polling, or Russia's main polling agency. What you can see here is in a situation when a regime very tightly controls the media space or the main media outlets, and essentially promotes the narrative that it does promote, that freedom online, let's say, is not of as important as other aspects and such. What happens is the following: is that in this country, 49% of people genuinely believe that the online needs to be censored, or 81% of the population are against any protests from the government, or the 42 and 41% respectively trust their governments, followed by Russian Secret Service to govern the internet. Obviously, this is a problem if you stand for, I don't know, internet freedoms or trying to promote digital rights online, because it is hard to make or to pass those laws if you can always point to the public opinion results and say, well, 49% of the government doesn't want that. They want the internet to be censored, or 41% of the government, from the society wants us and our, secret services to rule, to govern the internet. And there are several suggestions that I think come from this, or the practical steps that could be taken. So first of all, I would argue that in this situation, it's very easy and very straightforward for governments to say, for institutions like governments, the EU or NATO, which have been trying to increase their information capacities to influence places like Russia or the post-Soviet space institutionally. However, I would argue that that's not the answer, because the local populations, again, as you can see from the slide, 45% of Russians want to censor news media, right? So if you or think that foreign countries use internet against Russia, so if you're a NATO or an EU or a national government beefing up your information capacities, then you will face the issue of lack of credibility, that in the eyes of your target audience, this will be illegitimate and non-credible. Then what we try to do on our website, and I would propose in general, and quote-unquote East-West dialogue, especially of experts and expert communities, should be promoted via media outlets or via media platforms. This dialogue should be rooted in mutual engagement on the issues of common interest. So for instance, all governments, regardless of their position on internet freedom, probably want to combat, ISIS propaganda online, right? So if we start from there, then eventually sort of step by step, we can come to agreements, hopefully, on issues, let's say, on internet freedom. And lastly, assisting with capacity building for trusted domestic media outlets. And this correlates with point number 1. So basically, what I'm trying to say is that in the situation of this fundamental kind of distrust, oops, it's not working, but you remember the numbers. Sorry, it's not, the remote is not working. In this situation of kind of fundamental distrust of foreign governments, foreign news media, internet in general, in principle, by a lot of population in the post-Soviet space, what I think would be more productive is for those institutions and governments to work with independent private media sector, trusted domestic media sector, to increase their capacity and capabilities, because they know the local realities and they're struggling in most of these countries, and I think they're very well suited to speak to local populations and have the credibility to do so. Thank you.
Thank you, Stanislav. Now I will give floor to Kaltar, who has joined us also. Thank you very much. And Kaltar will be representing Mongolia and the business sector, and I think that you can then tell more about your organization. And also we expect from you perhaps giving us some Mongolian context to those discussions.
Good day, good afternoon to all, and for participation also. It's very thank you. And firstly, please, okay. And because of time limitation, I will present very briefly. No, we'll start from conclusion directly. No, Mongolia is a very freedom country, but we located in a very specific location. Now, between China and Russia, it's two big source of cyber war. It's very dangerous for us, and it's in on the other hand, we need to provide online freedom and freedom of expression. And it's very difficult for us because so many cyber attacks. It's need to protect Mongolian infrastructure, the internet infrastructure, and also Mongolian systems, and need to organize strictly controls on information security management systems and TC. No, but Mongolia now counted one of nations very free internet, and also freedom of internet and human rights in the Central Asia, in the region. No, but we have some deficiencies, also some faults, omissions. So we can, please not say. In Mongolia, no, human rights, online human rights is respected like offline human right. And therefore, our country is considered most free internet in Central Asia. No, but our government have the strong focus on providing internet access and protecting online freedom and human rights. Also, we actively engage with the private sector to ensure online freedom and freedom of expression interest. In the last few years, Mongolian government play a central and crucial role in supplying open access to internet and guaranteeing internet freedom, human rights, and securing rule of law online. No, therefore, by program e-Mongolia and e-government master plan, we already deployed nationwide broadband and for all citizens. Now only a few small towns are not connected to broadband. Other towns already connected to internet, and also all citizens have a possibility to connect to internet via cell phone, smartphone. So in every herders can connect to internet. No, but we have some omissions, some difficulties in providing online freedom. And for example, Mongolian children are not protected sufficiently in the internet because there is no law provisions on protecting children online. And also, their parents not sense importance of children protecting in internet. And also, law enforcement bodies also lack of knowledge, experience of steps. Because Mongolian policemen and judges don't have any knowledge and experience in cybercrime and against cybercrime, etc. Also, in Mongolian internet, more energy than online freedom, because no any restrictions, no any controls, only CRC Mongolia implemented some restrictions. No, it's mainly on United Nations principles for protecting citizens' reputations as etc. Briefly, we can be some example for other countries, especially for our neighbors in providing internet, online freedoms, human rights. But two neighbors is very difficult countries. And finally, Mongolians now inviting many initiatives on providing human rights and online, and also for providing freedom of interests. Thank you for
Okay.
attention.
Thank you, Kalte, very much for your input to the panel. I suggest that we now open the floor for questions and comments, if you have any. We have plenty of time to discuss some. You would like to react first, Corina?
I would like to add on the previous presentation about the direct link between freedom of expression and domestic media outlets. As I mentioned, in our own case, the mass media has developed a lot. We have a lot of private channels, and being previously with just one TV channel under the state broadcasting, and now with a lot of media privately, we started to have another problem, the transparency of ownership of media. And I think in dealing with the access to the information, and despite the fact that there are a lot of TV channels, still there are a segment of the population that will go to the internet and they will look into the internet, at the news. Even I'm looking at the Moldovans living abroad, that they know everything about the country, or about how the competencies even between the media and the internet. Because if to look at the public events, the internet has mobilized, for example, last week to have like more than 10,000 people going at the marathon. And the idea is that from where and how we are the internet and the media, but at the same time, it's in our young democracies, still we need the pressure, because just with the external pressure, we was managing to discuss about the new legal framework for internet users, for media ownership. And I think here it's about understanding every specific region, specific country, but at the same time, it's the limits or how to deal in order to have the final good result. And this is why we decided that on the human rights of internet users, it's about to develop the capacities of decision makers, to be strong from the beginning until the end, to avoid the pressure and to can overcome the pressure in dealing with such issues. Because at the end of the day, when we are using and discussing today about internet, about freedom online expression, this is about the security, and our region associates itself with the freedoms, obligations, but at the same time with the security of the country and of the region.
Okay. Anyone willing to react or question? Yes, please.
Thank you. I would like to add to the presentation by Mr. Halter. We have a relatively good regime of freedom of expression and online. However, we have still many challenges. For example, in our criminal code, the libel is a crime, and it's often used against the journalists and some people who criticize the government. And the current government just submitted the draft to the parliament, which still keeps the libel as a crime today. So we need to say against this crime. I think we can regulate the libel issues by a civil code or in less strict measures. In addition, we have no law regulating the freedom online, and we have lack of law protecting privacy. Thus, the internet issues are regulated by the bylaws, which are not based on the international standards and are not based on the statutes. For example, the regulatory agency shut down a website called Amjad.com, which posted a news about the former prime minister's campaign, some bad management, but within few hours the agency shut down this website, and fortunately the trial and appeal court, there was no legal basis of shutting down this website, but the agency hasn't allowed the website run until now, even though there are 2 court judgments. And there are many instances of the harassments and threats against the vulnerable groups, such as the foreigners, especially the Chinese citizens, the victims of domestic abuse, or the children, and the gender minorities. So why I'm saying about this case, the reason is that we need a statute law that not only protects freedom of online, but also right to privacy in a very balanced way. But in our constitutional law, the right to privacy has not been recognized well, even at the constitutional court level.
Yes. This is, I think, very, very interesting, and thank you very much for this analysis. And perhaps based on what you have said, question to Kaltar, or also back to you. We have here presented the Council of Europe Guide to the Human Rights for Internet Users, which is based on the European Convention of Human Rights. And Andri presented how this project has been implemented in Ukraine. My question is, would this be something relevant? Of course, the European Convention of Human Rights is a European convention, but most of the issues are relevant also to other countries. So the question that I have for you, would such a guide be helpful to you? Would this be helpful for Mongolian government? Would it be helpful for the Mongolian citizens, Mongolian private sector?
The Mongolia have many laws and regulations now, and many of provisions according to United Nations principles and the European conventions. But now we're developing data protection law. It's till now no any data protection law. But there is a state secret, organization secrets, and private person secrets law. No, we regulated online human rights and privacy by these laws. And now we already developed the data protection law, and I think in this session of Parliament will be approved this law. And in addition, in Mongolian criminal law, only 4 provisions, articles on cybercrime. This means it's regarding cybercrimes. It's full freedom in Mongolia.
Yes.
From Mongolia can make any alterations, any attacks at all,
Yes.
and no criminal penalties.
I think that I will take back from this meeting today and hearing from you that not only the guide but also the Budapest Crime Convention would be something very relevant to you, and I know that Council of Europe is working very closely with countries around the globe. So this is probably a message that I would pass from you, and I assume that there is already some cooperation going on between, or some contacts have definitely already been established between Mongolia and the Council of Europe. But I will just encourage, based on the discussion today, I think I will encourage. Yes, Andrei.
No, we already developed in Mongolian the Cybercrime Convention, European, and submitted to government organizations, but no reply till now.
Yes.
Maybe we'll join
Later.
future.
Yes.
Yeah,
Andrei.
but the Council of Europe Cybercrime Convention is open for participation,
Yeah,
not only members
Yes,
of the
yes,
Council of
yes,
Europe,
yes.
but
I discussing about this from 2000.
yeah. But one of the main principles of the convention is the protection of personal data and guarantees for lawful interception of communications. That's why it's very important to improve legislation and to adopt human rights standards in such field to join convention on cybercrime.
Yes, I think that we have to give floor to other participants as well. Is there anybody else willing to come in, or? Yes, colleague from UK.
Just a quick question, John Fox from the UK, and partly because you mentioned it this morning when talking about Russia and Ukraine as well. I mean, you obviously identified there that international institutions don't have great credibility. Some of the external media companies don't have great credibility. And I think you mentioned this morning that simply inventing a Russian language version of some website or a news agency wouldn't have great credibility. Now, of course, many of those are tools naturally at our disposal, particularly obviously the international institutions, and Russia is, of course, a member of the Council of Europe, as we've discussed. So I'd be interested in hearing, I mean, you said obviously partnering with local organisations, but there's a real problem there, which you're far more familiar with than me. But I don't think we've quite heard from you exactly what you're recommending is the best approach, particularly for governments such as my own, which do absolutely have a very active communication strategy at the moment to counter the Russian narrative. And I'd be very interested to just hear a little bit more of your ideas, but perhaps also in the broader context, since we've been talking about Council of Europe as well, as to how we can use some institutions such as that where Russia is a member to directly target such grievous abuses of human rights that we're seeing, and in a way that will actually get traction. I mean, the point you mentioned on using, for example, some of the natural diversity of media in Russia. I don't know the scenario well enough, but if it's anything, I'm more of a China expert. If it's anything more of a read across to China, of course, you know, they're going to be under sufficient strict controls as well. So I'm not really sure who these private companies are, where they sit, and why they would be more credible with the Russians, and in fact how Russians would watch them, why they wouldn't be blocked.
Mm-hmm. Stanislav, you want to answer on this? I will answer as well. Yeah. No, I will answer more generally.
Thank you for the question. First of all, of course, I don't have all the answers. I have some ideas, but unlike you, I'm not an expert in China, but more of an expert in Russia. So I don't know what the situation there. But for instance, in Russia, as much control and influence as the government has over the media sector, there are a number of well-established and very credible media organizations. I'm not going to name names because probably they're not going to mean much to everyone in this room. I know that in some countries, you know, like Uzbekistan or Azerbaijan, the situation is very, very difficult these days. And for instance, our contributors to our website from Belarus, Azerbaijan, Uzbekistan, they only write under sort of made-up names because they have careers and, you know, families and such. And so it is very difficult. To that, to be honest, I don't have an immediate and specific response. But I do believe that is something to think about. Because the other way is, in my eyes, is also not the response. So, you know, and don't get me wrong, I don't mean to sort of be negative about government efforts. So, for instance, you know, BBC, it's natural and it's obvious that governments or nation states want to be part of the information game or information arena. It's completely understandable and in many ways helpful or legitimate. But what I'm saying is that perhaps, especially with regards to the internet, there is room to start rethinking about the ways to go about it. And this whole presentation and what I said in our meeting earlier today was kind of inspired by seeing the immediate reaction to Russia's build-up information efforts, is that I saw the UK, the US, NATO, the EU, so essentially all the key players make statements, start to draft resolutions, start call for more funding. So it's almost like a knee-jerk reaction. And that got me thinking that, well, maybe that's not the way to go about it, because maybe that's not gonna help the situation, because one of the reasons that RT is so hugely popular around the world is because most of its viewers have no clue that it's based in Russia, funded by Kremlin, or backed by Russia. A lot of the people, or most of the people who watch RT, even if they support it, have no idea that it actually has any links to Russia. And this is kind of a hint into the problem that I'm trying to bring up. And had they known, maybe, you know, a lot of them wouldn't be as supportive of it. So that's just kind of the tension between credibility of such organizations among targeted and domestic audience, because like I said, you know, if half of the population wants to ban foreign news media websites, or foreign governments use it against their country, then you know, perhaps let's start thinking of other ways or other means, because that's probably not gonna reach the audiences and reach the goals that you know, that propaganda or information government information capacity is meant to do.
Yes.
Yeah. Since you
introduce yourself as well,
okay,
please.
My name is Xiao Jiang. I'm from UC Berkeley School of Information. My research is on China's internet censorship. I'm also a founder of China Digital Times. Since you said you're sitting between Russia and China, so I'll add a little bit of China information into the floor. I mean, with the people, it's well-known, well-established, documented facts that China's internet censorship, media censorship. But I just want to notice two recent developments. One is, put in a very simple way in the last 2 years, is that the Chinese government, particularly new leadership, President Xi Jinping, realized that despite all the censorship and control of the official media and all the efforts the Chinese government have been doing blocking the internet over the last decades, Chinese government is losing the ideological war on the internet. They are losing the control of the internet opinion. The public opinion overwhelmingly politically more liberal and criticize government, way beyond of government tolerance. This happens in the last few years, partially facilitated by the social media technology such as Weibo, which is sort of China equivalent of Facebook or Twitter. In that context, the Chinese government cannot win the war by persuading public opinion through their own media. They simply used rule by law, which is the forceful repression, the arresting public opinion leaders, framing them as prostitution or economic crimes, and humiliated them on the national TV in front of the country. So basically crack down in the physical space in order to control the online public opinion. That's domestically it's happening. Even that, I think that's only have a chilling effect, but only for a relatively short period of time, and the public opinion will come back again. But then another recent development, which actually being addressed, mentioned this morning in Tom, U.S. Undersecretary's statement, that in addition to blocking the websites outside of China that has information Chinese government see is undesirable, they started this online attacking, cyber attack, a real literal attack, that to GitHub and Amazon recently, which being documented very well by the Citizen Labs recent report called Grey Cannon. I really urge everyone to pay very close attention to this recent development, because this is no more that Chinese government is simply blocking the access to the foreign website. They are physically attacking the infrastructures in another country. In this case, it's United States, right? So you are for the information that they see is undesirable. And the technology the Chinese government being used practically can be used to against direct to any other country's infrastructure, not only just the United States. And also this attack involved another tactic, which is involuntarily used the citizens in other countries' cyber activity to become part of the attacking force. So there's all kind of legal issues and technical issues relating to China's new internet censorship. I really think this coalition should collectively making a statement on that fact.
Okay, now you want to react on this as well.
I would first of all just say that I have just googled that Freedom of House statistics show that Georgia is partly free on freedom of expression, but what about internet? It's free. And why it is so? Because we only block sites which have children pornographies, because in our criminal code only this not only this, but we have regulations for blocking the site under the court decision. What about other information how to block sites? We have our police makers have memorandums to foreign internet providers, and it goes under this case. For us now, it's not a challenge to have freedom of expression in internet. No, it's widely. It's more than to be freedom of expression in internet. We now need legislation framework to have some borders where is freedom of expression, and where we should protect another people's right of dignity, data protection, and so on. So in internet, I think we don't have cases, even we don't have cases for internet.
When you block, you don't really block.
No, only for children pornography, and it's good.
Okay.
Obviously.
Corina, would you like to add something in this regard? You referred
Well-
to the Budapest Convention and this being used as the reason to restrict freedom of expression. Very surprising.
Exactly. In our case, we started just to discuss some limits, and it already we finished with the discussions. But in terms of limiting some sites, even for child pornography, and especially for the implementation of Lanzarote Convention, once again, the Council of Europe Convention on child pornography, even on that, we are not blocking any sites. On the other hand, in dealing with propaganda, in dealing with freedom of expression, we are on the opinion that we need to have the proper legal framework. And if to go to the media, recent cases, especially for the last year, it was the Broadcasting Council monitored all the channels that were transmitted, for example, the news, but there was special methodology, there was the legal framework, and according to the legal framework, according to the methodology that was followed, there was some restrictions for a few channels. But the most important, I think, because in dealing with the last years with that issues, we come to the idea that we are discussing in the 21st century about the rights and freedoms, where everybody knows and they have the sense of these freedoms, and we can limit. It's just about how we can develop the responsibility. And I think this is the most challenging, let's say, obligation for the governments, how they need to develop the programs to develop the capacities, to train, even to educate the responsibility not only of the politicians, because nowadays we are discussing at the Council of Europe level or at the UN level about hate speech, but we are not talking about the responsibility of the general population, because when we are going to the internet, looking at the news, there are commenting not the politicians, but there are comments of the people. And I think this is the most important moment by now, because we can restrict, we can do anything. If to look at our neighbors Ukraine, they were closed some channels, but the second day there was critics, they like limiting some rights. And I think we need to, even in the framework of the Freedom Online Coalition, even together with other organizations that has mandate to develop the instruments to educate the responsibility. Mm-hmm. It's just the only one moment that we can use it right now. Mm-hmm. I think.
Thank you. I think I will have to conclude very soon, but I think I can give space for one more question or comment if there is, very shortly, if there is something. If not, then I think that I will conclude. I will make, I think, 4 points. They are not going to summarize all that we discussed, but perhaps for me to take back to Strasbourg some of the issues and some of the topics that will be relevant for the work in the next months and years. I think the first point is that the Council of Europe work in the area of human rights in digital world and online is very important, and it's not important only for the Council of Europe member states themselves, but it's also relevant for the countries outside. I think we mentioned the cybercrime, Budapest Cybercrime Convention, and also Data Protection Convention. Then secondly, the soft instruments, soft law instruments of the Council of Europe are also relevant, even though they have less binding nature and do not have direct monitoring mechanisms. And the Human Rights Guide is one of them, and we encourage, of course, all the member states to implement this guide and look ways how Council of Europe could support that work, possibly also with the help of the European Union that has so far supported the projects in Ukraine and Georgia and Moldova. And then third element is the capacity building. Capacity building is crucial in this to help governments, help politicians, ministers, parliamentarians, administrators, civil society, private sector to understand what kind of restrictions, what kind of freedoms, what kind of rights they have, and what kind of restrictions they have as well. And this is the question of the responsibility, I think, touched upon Corina. And then, as a fourth point, I take note of two issues: the propaganda, which somehow should be dealt more in the context of Council of Europe, and also the call by our Chinese colleague to Freedom Online Coalition to issue a more certain statement or more direct statement on China. I think I thank you for your participation and wish you a good continuation of the conference. Thanks.
Thank you.